memory isn't complete on this, but it says laws may not change a person's heart, but they can restrain the heartless. And I thought that's kind of what we're talking about today in some ways. I'm not having it in there. Slides? Do I have slides? This is my third year, I think, presenting on limited English proficiency, and I'm really grateful to the folks at the Idaho Fair Housing Forum for inviting me back again. And I think, I don't know if the Idaho Fair Housing Forum was acknowledged here, but I'd also like to acknowledge the people that are on the Fair Housing Forum did a lot of work putting this together. This didn't come about with a small amount of work. And the support of AMA, principally, who's providing the video service and the connection here, once we get it up. And Idaho Housing Finance Association and others. It's a very complicated effort. I think you all deserve a compliment to your own selves for showing up. You're the people that I think that those of us who are involved in fair housing don't worry about. It's the people that aren't showing up here today that we all should worry about. I haven't got my glasses on, so. Well, that's interesting. It isn't there. Did you send it to Brian? I've got a thumb drive. Is it? Sweet. Oh, they changed the name of it. Ah, there we go. Uh-oh. Aha. Do I use this? How do I do it? Just hit the button? Okay. Perfect. Thank you very much. Okay, I think we got it now. I'm here today to talk a little bit about Title VI of the Civil Rights Act and that part of Title VI that covers limited English proficiency. There. Oh, geez, I gave away half my presentation. If a person that speaks 3 languages is called trilingual, is known as trilingual, a person that speaks 2 languages bilingual, what's a person called that speaks 1 language? American. And that's part of the problem that we all have when we're dealing with this. I speak 1 language. But in the world, there are 6,000 or 7,000 languages. And in the United States, there's almost 400 languages. And what we all conveniently forget is 160 of those languages are indigenous languages. There's 18 sign languages in Central America alone. There are 25 million limited English proficient persons in the United States. That's 9% of our population. In Idaho, there's about 60,000 persons that are limited English proficient. That's about 4% of our population, so we're a little below the average. And in more than 10% of Idaho homes, a language other than English is spoken. When I looked at languages in the school districts here in the Treasure Valley a year ago, there was 80 to 100 in Boise. Meridian had 56, Canyon County 12, Twin Falls 21. And why is this important? That means that across the desk from you at any point in time, if you're managing housing in Boise, you may be having a client or a prospective applicant or tenant walking up to you and using one of these 80 or 100 languages. And you need to know how to deal with that, especially if you're managing federally assisted housing of one kind or another, or you're managing a federally assisted program or service of one kind or another. There are also what are called linguistically isolated households. In Idaho, that's about 2% of our households. About 1/5 of the households, Spanish-speaking households in Idaho, are considered linguistically isolated. The city of Boise does what's called an analysis of impediments to fair housing. And in the last time they did this, so this information is kind of old, but I show it to you because the refugees, when they talked with them, indicated that they had not received a verbal interpretation of their leases, or a translated lease, or other kinds of forms that were used. And if it was provided, they had to provide it for themselves. Now there's some legal underpinnings for what I'm about to tell you. And the first one is Title VI of the Civil Rights Act. And Title VI of the Civil Rights Act says that for federally assisted programs and services, that you must offer them without discrimination, including discrimination based on national origin, and that to me means limited English proficiency. There's also an interesting U.S. Supreme Court case. This comes from the San Francisco School District, where students that were non-English speakers sued the school district, alleging that they had been denied an education because all instruction and all materials were provided in English only, and they won. There's a presidential executive order that was issued by President Clinton in the year 2000 that instructed all federal agencies to address limited English proficiency in the offering and of federally assisted programs. Each federal agency was directed to issue guidance. HUD issued their guidance in 2007, so it's been around for 8 years. This is not a new requirement. However, how many in here manage USDA or RD housing? So there's a few of you. USDA, about 3 years ago, issued their guidance in draft form, and they have not yet finalized it. And this is true of some other federal agencies. But this is something that you need to know, is even without that guidance, you're still subject to Title VI of the Civil Rights Act. So who must comply? All agencies of the federal government, I mentioned that. But all programs that receive federal assistance, and so that's state and local agencies. Think of your city governments. Think of your police, law enforcement, your courts. It covers a lot of territory, Title VI. It can cover also subrecipients to these agencies when they subgrant that money. And that can include private, for-profit, and nonprofit entities like many of you work for. Now tomorrow I'm going to cover in a little bit more detail state and local agencies and limited English proficiency, but I'm not going to dwell on it today. Coverage. There's an interesting provision in all the guidance, including the guidance that comes from the Department of Justice. It basically says that if you receive federal funding in this part of your operation over here, and there's another part of your operation over here that is not federally funded, that you are still covered by Title VI of the Civil Rights Act. So what are the implications of this? So some of you probably manage federally assisted housing, and some of your housing is not federally assisted. Because of this provision, your operations with regard to that non-assisted housing may be affected by Title VI. It also means that when your maintenance guy is in the field, or maintenance woman is in the field, working on a daily basis, and somebody approaches them speaking a language other than English, and this happens to be a federally assisted housing project, that person needs to know how to address that person that's a non-English speaker, and we're going to talk about that. I love this slide. Every year I show this slide, and every year I tell people I love this slide. And I do love this slide. There's a couple of ways of looking at equality. This is the way the limited English proficiency guidance issued from these agencies looks like, from your standpoint. It means that in order to present an equal opportunity to non-English speakers, that you need to do more than speak to them in English. It also means that if you're able to have a conversation with somebody in English, that does not mean that they can also read a document in English. They may not be literate in English. So that means that you may have to up your game. It may mean that a person that can speak English, and you're talking about loan documents and loan provisions or a lease violation, is not going to understand that in English, and so you're going to have to work with that person and provide language assistance to them so that they can understand it. So what is limited English proficiency? Well, if your primary language is not English, and you don't read, write, speak, or understand English very well, then you're considered limited English proficient, or LEP, and I'll use those terms interchangeably from now on. What is language assistance? Well, there's really two kinds of language assistance, interpretation and translation, and it helps to understand the difference. Interpretation is the oral conversion of one language into another language. Translation is the counterpart to that in writing. And down at the bottom there I go, but what about gesturing and pantomiming? And what about speaking louder and slower? We've all done it, right? Here's the thing. I've had people try to convince me that they pantomimed or gestured, and they were able to communicate some pretty complicated program provisions to persons that did not speak English, and they were certain that these folks understood perfectly what it was that they were trying to be told. I don't think that that's the case, and we shouldn't believe that's the case because it's not the case. I've begun to try to, as I work with my clients, talk about full spectrum language assistance. And this is kind of a new thing for me, and I think it's an interesting way to begin looking at what's important to you. Because there's what they call low and no touch and high touch. And over in the high touch area, you're dealing with federally assisted programs, services, housing of one kind or another. High impact kinds of things, maybe you're dealing with a lease violation or a potential eviction. High risk, we already talked about the fines that you can potentially suffer if you violate somebody's fair housing or civil rights. So that's kind of the climate that assisted housing providers are working in. On the other end of that, you're dealing with things like where there is no federal assistance, there is no or low impact. So you can talk about the weather. Even on an assisted housing project, you don't have to call in an interpreter to speak with a non-English person, a limited English proficient person, to talk about the weather. You may be able to pantomime, can you move your car? And that might be important if the car is in the way of the garbage truck, but is it, it's not high impact generally unless there's some resistance there, and then I would say call an interpreter. So we'll talk about child interpreters, but you see on the low end there, if you're talking about the weather and a child is interpreting, that's probably just fine. If you're dealing with that over in the high touch area, one of these high impact or high risk areas of language assistance, you want to think about that in terms of, I want a really good, competent interpreter to help me through this. What I would like you to do, you guys could really help me. You have a copy of my slide presentation here. And I would really like you to take a look at this. I'm not going to spend any more time on it. But I would like you to take a look at it, and if you have some ideas for me to add or improve this or some other ways of presenting it, I would really like your ideas. And if you email me or call me, get in touch with me some way, I would really like to hear from you and develop this a little bit more, because I think it's helpful. Not everything is covered by Title VI. What the LEP guidance from the federal agency says that you need to do is put in place a language assistance program. And the language assistance program consists of several pieces. You need to determine the needs. That's called the language needs assessment. You need to develop a plan. That's called a language access plan. You need to train your staff. You need to monitor what's going on, what's working, what's not working, what has changed. Maybe more languages now. There's a new group of refugees have arrived. They speak a different language. Maybe you need to change what you do in your protocols in your front office. You need to evaluate what you need to change, and then you need to update your plan. And you should do this at least annually. This plan, the language access plan and the language needs assessment, are both physical documents that you should have. Here's the rule about interpretation. Remember, this is the oral conversion of one language into another. The rule is that once a person is assessed as being limited English proficient, and that person is seeking what's called meaningful access to basically programs and services, in your case housing, that person is entitled to competent, timely, and free language interpretation. And that is something that you have to provide. And while it's free to the person, it's not free to you. This is expensive stuff. People that have done it understand this. There's some cautions throughout the LEP guidance from the agencies about using children to interpret. Remember, I just told you could use them, but I said you could use them when you're maybe talking about the weather or something unimportant. But if you're talking about an eviction or you're talking about loan provisions, and I actually saw this happen, and it did not go well and should not have been permitted. But basically, do not use children in these interpretation events. Remember that there are different dialects. Guatemalan Spanish is different somewhat from Mexican Spanish. So remember I said it had to be competent interpretation? So when you're finding an interpreter and you have somebody from Guatemala, you try to work with your interpreter to find out if that interpreter is the person to have or if they need another interpreter. There is no safe harbor for interpretation. If it's needed by an LEP person and it involves access to services and programs and your assisted housing, you have to provide it. Translation of documents. Well, the documents that need to be translated are called vital documents. So these are the documents that provide that meaningful access to, in your case, housing, programs, or services. So in your case, what are some of those things? What are vital documents in your world? Vital documents in your world might be your website, because that's where you tell people about your housing. It might be your ad in the newspaper that you put in there if you have a vacant unit. It might be your marketing brochure. It might be your application form. It might be your lease agreement. It might be your selection criteria. So these are all vital documents that you need to think about translating. The one thing the LEP guidance does for you is offers you what's called safe harbor. And what it's saying to you basically is, translation is expensive. We understand that. Well, the federal government understands that. We understand that, and we do not expect you to be 100% fully compliant on day one. But what we want you to have is a plan for when you're going to translate certain documents, and it establishes certain thresholds of where and when documents need to be translated into certain languages. Now, there can be other reasons that you translate a document. For instance, if you have to continually interpret a lease agreement to somebody in a particular language, and you do that 3 times a week or 6 times a month or whatever, to pay an interpreter to come in and do that for you costs a lot of money. It may be less expensive for you to translate that document, so based on a business decision alone, you may want to translate a document. Oh, I accidentally hit that. Okay. Those of you that are in managing assisted housing, you also have to do what's called an affirmative fair housing marketing plan. And the affirmative fair housing marketing plan, it's attempting to help you analyze the demographics in your property in terms of ethnicity and race, and harmonize those with the demographics in your market area. Now, when I work on a language needs assessment, I'm looking at those thresholds to see what document, to identify vital documents, and then in what languages that document needs to be translated into. So while these two things sit there independent of one another, they kind of relate to one another too. And they may give you different answers that what you need to do. You may need to increase the number of Asian Pacific Islanders in your property to harmonize your demographics, but my language needs assessment would not indicate that. So you need to know that sometimes what you need to do in terms of language assistance can be different based on where you start and which of these two documents that you're looking at. There's several reasons to comply. It might be to expand your market. It might be to provide that good customer service that I think everybody in here that is working with people in this kind of way would want to provide. Maybe to comply with the law. We hope that's true, so that you're providing that meaningful access to programs, services in your housing, and avoiding complaints about disparate treatment of one kind or another. But it also may be to manage risk, and this may be one of the more important parts of this. Think of your language access plan as a good karma bank. Because if, for instance, you have put in place all of this language assistance program that I had mentioned to you, and you do receive a complaint based on limited English proficiency or your failure to comply with the law regarding providing language assistance in a way it should have been provided, and let's just say that you messed up or your staff person messed up. Well, what happens is they look at this and they look behind the event and they see if you have done what you needed to do, that you didn't intentionally do this, that in fact you have established this language assistance program, you've trained your staff to it, it just was something that went wrong one day. Then it has a way of moderating that penalty phase that both Zoanne and Wendy have talked about, and also Bill. So the language needs assessment, the language access plan, the language assistance program, that whole package is something that's really important to you. Here's a case study. Housing provider basically had a tenant that failed to recertify her annual income. She was evicted. It turns out that all the correspondence and all the verbal communication with this person was in English, not in this person's language. It also turned out that housing provider had bilingual staff but no policy to use it. They had not done a language needs assessment or put in place a language access plan. So how many of you think this is going to go well? And it didn't. First of all, the complaining party was paid $25,000. And this is when the housing provider realized that they really were bilingual. They were told to adopt a limited English proficiency policy and complete a language needs assessment and put in place a language access plan. They had to improve their procedures. They translated documents. They trained staff. They coordinated outreach. Well, the thing that you need to understand is these are things that they needed to do anyway and should have done. Here's the difference, is instead of doing it on their own schedule, now they're going to do it on HUD's schedule. And if that becomes a budget problem, HUD is going to care less. So the golden rule is put in place a language assistance program, follow it. Don't put it in place and not follow it. That's a huge problem in itself. And then document. Document every interpretation event that you do. Document what language it was, how long it took. You may want to do that for cost purposes. But you want to know what it is, where you're spending your money and why, and in what languages. And would it be cheaper to translate a document than continually interpreting a document, for example? Document when you translate those vital documents that I mentioned, so that you're continually keeping up to date on what's going on with your language assistance program. There are lots of resources out there. U.S. Justice Department of Justice has the lep.gov. It's a wonderful website. It has a lot of information. It's updated periodically with new cases if you read those things. A lot of them are law enforcement and court related. Not so many of them housing related. But there's a lot of resources there. Also, my website, I'd like you to visit my website. There are resources there that you can download for free that I've put there and had them there for years. And I want you to use them. We just rolled out Language Finder. Language Finder, for those of you who work with languages, also probably have worked with language identification posters. This is a language identification poster in your smartphone. So if you're in the field, your maintenance person is in the field, and they're not sure what language somebody is speaking, they can use this to help identify it. Also, on my website, there's a LinkedIn button. I publish articles every once in a while about language assistance, latest cutting edge kinds of things going on, and there's a lot going on in language assistance around the world. But this is a way to stay in touch with some of those changes that are going on, and they're going to affect you in big ways in the next 5 or 10 years. Now, Zoanne, we want to talk a little bit about Title 8. Very little. We're running late.
No, we're good. I guess I have to be in front of the camera a little bit, but I'm a wanderer like my sister. So just a couple of things I want to mention about Title 8 is that not only can someone file a Title 6 complaint, what Gary was talking about, but they can also look at if you're treating people differently or denying housing because someone is not limited English speaking proficient, usually because of their national origin. And what we found when we call and inquire about housing from housing providers or someone who's seeking a loan or some access to a housing program is that a lot of times people are hung up on or they're redirected and steered to some other resource where they are hoping they would get some language service. Have a plan in place. It's really important. That's why Gary is saying, make sure that you're not denying someone access to your really important critical service. You provide housing, and we want everyone to be able to access it, whether they speak English or not. And so make sure you have a process in place. The other thing that we are starting to hear about is people who are actually proactively marketing and renting only, or in a very overt fashion, to people based on their national origin, but applying different terms and conditions when providing services, meaning they're actively advertising to people who speak Spanish, or who speak Swahili, or who speak Russian, but continue to provide their documents only in one language. You may or may not be legally required, based on whether or not you receive federal funding, to provide written translation, but at least provide some sort of interpretation in those instances as well, because you are actually marketing to these families. Will it be required? We'll see. We know that it is when you receive federal funds, at least for interpretation. Maybe if your active plan is to actually actively market to these groups, are you actually providing the same treatment or different treatment when you're specifically marketing to a language group? And the other thing we're seeing is that when people are accessing housing programs, particularly loans, we're finding that the translation services, when I contact the person, they tell me what's wrong for a loan modification, for a refinance. When my consumer who speaks Spanish calls, they're given different information, less quality service, and worse terms and conditions. When I call them again, I'm calling on behalf of this. Oh, no, I didn't say that. This is it. My colleagues speak Spanish, so we know what is said to us, and we know what is said to our consumer. That's difference in treatment. That is a Title VIII violation. That is a violation based on national origin. Be very, very careful that when you're speaking with people, we're treating them equally. It's a critical issue, and when you're seeing Title VI issues, you're also typically seeing Title VIII. So, thank you.
I realize I stand between you and lunch. So I have one last slide. Thanks to George Carlin, he reminds us that everyone smiles in the same language, and I hope that we can all continue to do that. Thank you very much. I don't know if we have time for questions, but
if you guys did not check in, please do go to the table and check in, because that's the only way we can get you your certificates of attendance. You must check in.